on immigration law vis-a-vis citizens, my lord. There are 6 principles, my lord, which I will just tell your lordship, my lord. That's the first, my lord, principle which I will be addressing your lordship, my lord, which is subject to your lordship permission. Secondly, my lord.
No, once again, jurisprudential principles.
Principles internationally recognized on immigration laws vis-a-vis citizens' right. And they are all part of my, my lord, written submissions. I will give the para numbers also, my lord.
All right.
Second, my lord, the global refugee policy, my lord, as my lord as declared in United Nations refugee policy, my lord, 1951. Refugee policy of 1951, to which 146 members are signatory. India is not a signatory. Recognizes only right to abode and not to right of citizenship.
But Mr.
Yes.
Hansaria, what that means is no individual can move a court
Yes.
relying on an international covenant
My lord.
and say you are bound to confer citizenship on me. No
Look,
individual has the right.
I'm,
But this can never preclude the sovereign right of a nation.
I'm not saying Parliament is not sovereignly competent on this. I'm just broadly saying, Lord, what are the internationally recognized principles on that? Lord, I cannot get a mandamus or a seizure from your lordship that 6A must be struck down on this. But these are the broad principles my lordship would keep in mind while interpreting. And I'm going to submit, Lord, these are part of our preamble and constitutional ethos.
All right. Second,
I'll develop that.
Third point.
2. 3, my lord, as Mr. Chaudhary has said, my lord, I will demonstrate that with article there. Section 6A in effect amends Article 6 of the Constitution. I'll show that how. And it could not have been done without going through the process of 368.
Amends Article 6.
In effect, Article 6 of the Constitution, 6 and 7 of the Constitution, my lord. It amends Article 6 and 7 of the Constitution. In effect, I have got, my lord, the chart, my lord, by how it has been amended. In effect, my lord, Mr. Diwane said you cannot discriminate within homogeneous group. I'll show some materials to show, my lord. Assam, along with 4 border states of the eastern part of the country, my lord, are homogeneously placed with materials to support that Assam has been singled out and discriminatory, my lord. This so far, if you're making it applicable only to Assam. The effect is, my lord, not only that they are staying back, they are coming from the neighboring states, my lord. If your lordship knows, my lord, from Guwahati to Shillong, if your lordship go, one side is Assam, one side is Meghalaya. If you are in this part, you are Indian citizen. If you are in this part, you are an illegal migrant. So all that it requires, cross that road and claim citizenship. And I will show, my lord, from the materials on record, what is the extent of, my lord, illegal migrants in those states, and what is the extent of illegal migrants in Assam, and what is the extent of border, my lord, of the 4 states and us, to show they are homogeneously placed, my lord, and you have discriminated only Assam, my lord, quad that. I'll show that. 5th, my lord, as Mr. Chaudhary said, I'll just develop that little more, that subscribing an oath of allegiance to the Constitution of India is a basic feature of the Constitution. And the persons who have come, they have not come from Bangladesh, my lord, because Bangladesh is not born on 26th March 1971. Bangladesh is born on 26th March 1971, not on 25th March 1971. And on that day, they are the citizens of Pakistan, in which, my lord, the Prophet says, Prophet Allah is the only person who has made the earth. I'll show that, my lord, I have quoted it. So unless they renounce their citizenship of another country, which believes in a, my lord, particular religion, you cannot become a citizen of the India, or which is a, my lord, a secular country, without subscribing an oath of allegiance. And that is what is required in section 5 and 6, my lord, that wherever you become a citizen by naturalization. Next point is, my lord, the India has a refugee policy, my lord, qua Tibetan, qua Chakmas, qua Tamils, and qua Rohingyas. None of the refugee policies, my lord, confer an automatic deemed provision for conferring citizenship. There are definite policies of rehabilitation for the refugees who are these 4 groups, my lord. None of them confer an automatic citizenship, much less a citizenship by an application. And this is discriminatory. My lord, first, my lord, and the finally, my lord, BK Sharma committee report, lordship has seen 1462, my lord. What it says finally, my lord, it says, in case it is to, in the meantime, what is to be happen. And I will give a case law, my lord, to your lordships on discrimination under Article 14. I'll give a list of.
Hansaria?
Yes.
Can you go straight to your third point, that section 6A in effect amends Article 6 and 7?
Please, I'm grateful to your lordship.
Then we come back to your earlier
point. Please, your lordships. I'm extremely grateful.
Showing us the material extent.
Done. I've typed Article 6 I've engrafted 6A, how it is amended. To just, it will be easier for me to demonstrate that, my lord. It has Article 6 and how Article 6A has been incorporated there. Just give it to that.
What are the track changes in the
No,
document?
this is Article 6 of the Constitution,
Right.
which is there, my lord. What I've struck off is what is the effect of Section 6A. And, my lord, how it has been, my lord. So, Article 6, if your lordship kindly keep the Constitution side by side. I have typed Article 6, my lord. And whatever has been changed because of Section 6, I have struck off. And in italic, I have put what is the Section 6A has superimposed on that. So, lordship may kindly keep side by side. Article 6 of the Constitution says right of citizens of certain persons who have migrated to India from Pakistan. What 6A says, Lord, who has migrated to Assam from Bangladesh. In effect, I'll show Section 6A also, Section 6A. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be citizen of India at the commencement of. So there is a deeming, by way of a deeming fiction, my lord. A person who would not become a citizen of India is deemed to be a citizen of India in respect of those persons who have come from Pakistan. Now, my lord, this specified territory is a part of Pakistan. Is a 25 March 1971 is the cutoff date, on which date it is a part of Pakistan being East Pakistan. Bangladesh is born on 26th of March 1971.
Just one second.
In paper, 26 March, in actuality, 16 December 1971, after India won the war.
What is the date on which India recognized Bangladesh?
16 December 1971, when India won the war.
But then what is the relevance of 25th March?
Because, my lord, Bangladesh declared itself to be a country.
It declared its independence.
Itself to be independent on 26th March.
But we recognized Bangladesh in December.
Because after Indo-Pak war, my lord. From 11 December to 16 December. And it declared its independence on 26th
So on
March.
25th March, according to you,
Yes, my lord.
Bangladesh was an integral part of
Pakistan. And I have got
And if you're from Pakistan,
yes,
then the only date was 19 July 1948.
please, your lordships.
But even there's a problem in your argument.
Yes, my lord, let me understand.
I mean, theoretically,
Yes, my lord.
Parliament may not do it.
Yes.
But it was always open to Parliament to say, what does Section 6 do? Oh, sorry, what does Article 6 do?
Yes,
Article 6 is qualified at the commencement of this Constitution.
my lord.
That is to say, persons who had already migrated from Pakistan, in fact, this I must share, just as Brother Sundaresh pointed this out to me a short while ago. Persons who had migrated from Pakistan prior to the birth of the Constitution on 26 January 1950, they would be conferred citizenship, or they would be deemed to be citizens, subject to certain conditions.
Yes.
One was either of the parents was a
Yes.
citizen, or they were either of the parents or grandparents were born in India. Then B, in the case where such persons so migrated
Yes,
before 19 July 1948 and has been an ordinary resident of the territory since
my lord.
the date of the migration.
Yes,
Right? Because 19 July 1948, they probably took as the partition
Yes,
appeal.
yes.
Approval.
yes,
Therefore, what Article 6 does is to confer citizenship on a class of citizens, on a class of persons who had migrated from Pakistan prior to the date of the adoption of the
My
Constitution.
lord.
It freezes it as that. But that does not prevent or that does not dilute the power of Parliament under Article 245 and 246 and Entry 17.
Entry 17.
And particularly in the context of Article 11, even to confer an extended citizenship on persons coming from Pakistan itself. I'm saying,
My lord.
forget Bangladesh, but test it only for the purpose of a hypothesis. I'm not saying that they will do it.
Yeah.
But there is nothing to stop Parliament from saying that we are now, in exercise of our power under Article 11, also conferring citizenship on a group of persons from Pakistan post 1948. In which case, the fact that technically on 25th March 1971, Bangladesh was still a part of Pakistan
My lord.
would not really affect the power of Parliament.
My lord, may I meet that, my lord? I'm extremely grateful to your lordship, my lord. What Article 6 and 7 says, my lord, by deeming fiction, it could have said, my lord, before the commencement of the Constitution, as Article 3 has said, Article 5 has said, my lord, all persons born before the commencement of the Constitution, it has chosen to fix a date, my lord, of 19th July 1948 who will be deemed to be a citizen, otherwise they will not become a deemed citizen.
So you are reading Article 6 as exhaustive.
Is exhaustive so far as deeming fiction is concerned, my lord, of people coming from Pakistan. In effect, my lord, does it or does it not, lordship would test it, my lord, amend the constitution.
All right.
Say, my lord, that those who come before 1st July 1966 and come to Assam from Bangladesh would be deemed to be citizen. I have no difficulty, my lord. They can make an application, acceleration. Parliament has made section 6, 7, etc., my lord. No difficulty. But can you make a deeming provision, my lord, by saying, yes,
I've understood your argument
Yes.
right. We'll phrase it in a proper way.
yes,
Article 6
Yes.
provides for a deeming fiction by virtue of which persons who had originated in Pakistan were conferred citizenship, provided they met the cutoff of 19 July of 1948,
my lord.
or in some cases even beyond. When Parliament legislates under Article 11 in respect of persons originating in Pakistan, you cannot introduce any other deeming fiction.
My lord.
Because that deeming fiction is provided by the
Parliament,
substantive
by
provision
the
of
Constitution.
And on that day, 25th March 1971, these areas in specified territories were a part of Pakistan, and therefore Parliament cannot really, by a deeming fiction in exercise of its power under Article 11, introduce a contrary deeming fiction.
My lord,
See, that's the point. We'll hear the other
Lordship
side.
would test my argument. Just one more sentence. Suppose, could the Parliament have said, my lord, 25th January 1950? 26th January, it was Article 5 say commencement of the Constitution. Lordship would test my argument, my lord. Could the Parliament have said anybody who entered on till 25th January 1950? It could not have, my lord. If it could not have said 25th January 1950, which is a day prior to the commencement of the Constitution, it definitely cannot say, my lord, on 1st January 1966. On what basis, my lord? Because it is in the teeth of Article 6, my lord. If Article 6 completely, my lord, encompasses the persons of deemed migration who has come to India from Pakistan.